Welcome to the TuckerAllen podcast. I'm Scott Trout. I'll be moderating today as we talk about issues related to estate planning and elder law, the questions that everyone has as it relates to those issues. We'll try to cover those topics as we address those each week with our guests and attorneys from TuckerAllen. If you have any questions, you can visit us online at TuckerAllen.com, or you can give us a call at 314-335-1100. So joining us today, but before we do that, let me make a word of caution. That is, don't take this as an attorney-client relationship. This is not legal advice, obviously. We have 10 to 15 minutes. We want to just give you some speaking points, some topics that you can address with an attorney when you have these. So get a pencil, paper, write these down, and then find an attorney who practices exclusively in estate work and elder law, and talk about these things. So I always start my podcast that way. We talk about, not being an attorney-client relationship, but we are available to meet with you. We can do it virtually, via phone, and in person where you feel comfortable. Again, you can find us on the web at TuckerAllen.com and schedule an appointment, or give us a call at 314-335-1100. So I'm joined today by one of the TuckerAllen attorneys. Welcome, Ryan.
Good morning. Thank you for having me. I appreciate the opportunity to kind of go over this and get some of this information out there to the public.
Yeah, there's questions like I have, obviously, that everyone who's listening and watching has. Oftentimes lawyers use the big words, the legal words, and we make assumptions that everybody understands it. It's much like an engineer, an architect, or a doctor who throw these words out because they use them every day. And so maybe we start with the one that, it's very confusing, and it's a lofty word, and we call it intestate, and testate. And what is the difference? What does that mean? It's kind of a fear factor when you throw that word out, and, if you die intestate, what does that mean? Everybody wants to know, kind of give them just a basic level of understanding of what it means and why it's important to understand what it means.
Absolutely. So intestacy being terms that are typically used for probate court. What that means is if you are intestate, you've passed away, and when you passed away, you didn't leave a will. There was no estate planning done on your behalf that indicated who you wanted to be in charge and where you wanted your assets to go after you passed. Obviously, dying testate then is the opposite of that. That is passing away with a will. And that determines how the probate process is going to go and whether your assets are going to pass along the route that you went ahead and set out, or if they're going to pass by the intestate laws.
So obviously, it's not necessarily, I always hear it's not a good thing to die intestate, right? Without a will. Is that a fair statement?
Absolutely a fair statement, yes. It's much better to have a plan in place because while it's great to have the state statutes to fall back on, we're glad there's something there. The court process is always going to be more involved and more expensive if you don't have that will to give the judge. If you are passing testate, your will basically acts as an instruction sheet for the judge.
Yeah.
When it goes into probate court, the judge gets to look at that will and knows everything that needs to be done, and it speeds up the whole process. It makes it a lot cleaner and quicker. Now, that doesn't mean it is clean or quick, but it is cleaner and quicker than intestacy.
Right. I mean, it's the conversation that I've had with my grandparents. It's about, avoid the word testate or intestate, but you need a will, you need a trust, Grandma. You can't die without it because, and this leading into the question I have next for you, and that is, we want to follow your wishes. We want to know what you want to do. We don't want the court, we don't want the government, we don't want someone else that you don't know in control or to follow something that maybe you didn't want to happen. So that kind of leads into the question of, who makes those decisions for me after I die about, will they follow my wishes, and who does that for me?
Absolutely. So focusing in more on the probate side of things, the probate side of things today with the intestacy and the testacy, just a will, where we can talk about trusts hopefully at a later date. The person who makes those decisions is going to be either the personal representative, who is someone that you have made a will and you've chosen to be the person who executes the wishes that you put in that will. In fact, that person, I said, executes the wishes. That person used to be called the executor. You may have heard that term or be more familiar with it, but it's passing out of the common language now. You'll hear personal representative almost every time now. But if you died intestate, then that person is going to be an administrator, which is someone that the court has appointed. Now, the court just doesn't go and do this on its own. Someone has to petition the court to open the probate and to set up an administrator. So again, like I said before, this is just complicating the process, drawing things out, and making it more expensive for those who have been left behind. But there's also the potential that an administrator can be appointed if there was a will, because you didn't choose someone who's actually available. There are situations where in the will, the person who has been elected or nominated to be the personal representative has passed away, has predeceased the person whose will is being probated.
Right.
And so if they're already gone, they obviously can't do the work that you had nominated them for. So it's important to make sure that you have a succession plan in there. I know at TuckerAllen, and I assume most other law firms as well, when you nominate someone as personal representative, we'll ask you, now if they're not available, who next? And if they're not available, who next? And so the will has built in those terms to make sure that that doesn't happen. You don't wind up with a court-appointed administrator. You have someone that you picked because you believe they would follow your wishes.
And are they required to follow your wishes if you've outlined them specifically in the will?
Absolutely. Absolutely so. And that's part of the court's position in all of this. While you have a personal representative whose duty it is to go ahead and follow the terms of the will, the court's duty in all of this is to make sure that the personal representative is doing their job. Mm-hmm. A good example of this would be, say, you didn't want the house left around, you wanted it sold, and just the proceeds to go to all your kids split out evenly. Well, the court is going to supervise the sale of the home and make sure that you're getting a fair market value on that sale, that you're not, selling it to one of the kids for, half of its value to shortchange the others. So there are safety steps built into this so that your wishes, if they are written down, are very carefully followed.
Yeah. And so it's very similar. I think at the time I had these conversations with my grandmother, and instead of, her thought was, well, I don't need a will. I'm just going to she would take masking tape and write someone's name and put it on the bottom of items. Right. And I said, Grandma, it's exactly what the will's going to do. You don't have to put masking tape that, who knows, maybe the writing bleeds off or we get in an argument about who wants it. I said, that's exactly what the will, isn't that? Isn't that pretty much what, you're trying to show what your wishes are? You just call a will the masking tape of estate law, right?
Yeah, you can certainly do that. And I definitely recommend having the will over the masking tape.
Yeah.
I've seen color-coded stickers. This child gets the red stickers. This child gets the blue stickers. I've seen all kinds of things like that. The will is a much better idea.
Totally.
We had a lot of conversations on what would happen if we weren't here, and I don't know. TuckerAllen was super convenient. It was so easy to go through and get the package that we needed.
The website was simple, easy to use. You could schedule a time to actually meet with somebody.
It's one set fee for a will, one set fee for a trust.
It's our wishes in place. It's everything we want for our daughter.
If you want to make sure that certain specific items go to certain specific people, you can. You can put that in the will. You can have a personal property memoranda as well if you wanted to do a trust. Yeah. Those documents are there for that purpose, and that's the best place to do it.
So, I guess the opposite being, everyone's listening, they're thinking, well, that sounds great, but it's not that important to me. But maybe I think to stress why, as I did with my grandparents, is what happens when I die without a will, that intestate kind of position. Maybe that's the point that, in my mind, convince someone to do something. So to kind of maybe quickly walk through what happens in that situation.
Sure. So, like I said earlier, we have these statutes to fall back on. That's what happens. If you have failed to outline anything, we fall back on estate planning by the state, what they think should happen. So I believe it's chapter 474 of our statutes. If anybody wants to go look it up, you can read them yourself. They're all online and you can get access to them. You might not understand them on a first reading, but they're all there. It lays out the plan for anyone who dies intestate. So Missouri's plan, we'll start here, is with the spouse. So if there's a surviving spouse, the surviving spouse gets everything if there aren't any children. If there are children, and the only children that there are the children of both you and your surviving spouse, then your spouse will get half plus $20,000. And anything after that will get split amongst the children. And if it's a blended family, if there are stepchildren, then, and I think I might be getting ahead of myself a bit there, but if there are stepchildren, then the spouse simply gets half. And Missouri is what you refer to as per stirpes, which is a legal term. It means by the root state when it comes to how things are passed down. So say we've got 3 children, but child number 1 has passed away already. When things pass, it'll go 1/3 to child 2, 1/3 to child 3, and the last third will get split up amongst any children of child number 1. So that's what per stirpes means. And like I said, this is great to fall back on. And some people, this is exactly what they want. But it doesn't take into account anything such as, well, I would have wanted to disinherit this child, or this child has been taking care of me for the past 10 years, and I want to make sure they get some extra to help, take care of them and thank them for the time that they spent. Or I'm afraid that this child's spouse is going to divorce them soon and take all of the money away. Those are all concerns that can be addressed with an estate plan that you've made with an attorney that cannot be addressed by the state's one-size-fits-all intestate plan.
Yeah. It sounds so complicated. That's the thing. We don't even have to worry about the per stirpes or the per capita. If you just take the steps to sit down with someone like you, talk about what you want where you want your stuff to go. And I mean, I think that maybe that's an innate thing for many people. Is like, when I go, I want my family taken care of. I would, maybe there's something particular, like a watch. I want a watch to go to this son, and then maybe you're estranged from somebody and you perhaps don't want them included in your will, and you don't want to fight. And it's so much easier to spend a few hours to dictate what happens rather than get into this legal situation of following a statute and then trying to figure out who gets 50% plus 20,000. It's just, to me, it becomes so simple to just say, it's time to do a will, don't you think?
Oh, absolutely. And as far as TuckerAllen is concerned, our prices, if you want to look, are out there on our website. But you have to compare that with, here's our price, here's how much time it's going to take. Now look at the court process.
Yeah.
If you pass away intestate, the cost usually ranges between 2% and 5% of the value of the entire estate. So the more complicated the estate is, or the more messy the family situation is, that can go up. But on top of that, you have the time.
Yeah.
Because you come in, you meet with an attorney, it's an hour, hour and a half, and then you have to come back later for a signing or to review your documents, and you're done. When it comes to the intestate process and going through the probate court, you're lucky if it's 6 to 8 months right now. That is a huge time investment. And the idea is that you're doing this for your loved ones, because if you think about it, at this point, you've passed away. But the people you love are now bound up in this court process that's going to dominate their life for the next half of a year or more. And anything that you may have wanted to give them is now being reduced by that court process. I mean, all of the costs and the time that goes into it.
Right.
So it really is a no-brainer. Go and find an attorney and get some sort of plan in place, because in the end, while it feels like a lot of money up front to some people, it's going to save you so much more down the line.
Yeah, why pay a lawyer, 5% of the estate value when you can pay them $1,000, $500, whatever it is, depending upon what you build, right? And as you suggest, go to TuckerAllen.com, check out the price structure for what you think is appropriate, and then have a consultation, because it is. I'm all about minimize the expense, minimize the intrusion into your family, into your estate, and direct how you think things should go. But more importantly, I think one of the as I think through the conversations I had with my family is, this generation, well, if I just do this, this, and this, I don't have to worry about it, put someone's name on the title, but then inevitably maybe they forget to do everything. It is make sure it's all taken care of, because issues, I wouldn't want to spend 2 to 5% of my estate value and have my kids not get it. And instead a lawyer that I don't know, or a court system that I don't trust, whatever it may be, it just seems like a no-brainer to invest that kind of money. It's like buying a new car, and albeit the warranty may be free, and you just say, you know what, I don't want the warranty. I'll take my chances, right?
Yeah, that's about it. It's a much safer option to go ahead and make an estate plan.
Yeah.
One of the biggest things it avoids as well is conflict within the family.
Mm-hmm.
It's unfortunate, but you do see in intestate estates especially a lot of fighting, because there's no wishes left written down. Families that you would think would have no issue going through these circumstances wind up fighting tooth and nail over the smallest things. This was last year in Jackson County, if I remember correctly. There was some case where all that was left was a china cabinet. Now, it was from the late 1800s, and it had a lot of sentimental value, but they fought about it in court for so long about who was going to get grandma's china cabinet. I think they eclipsed the value of the cabinet like 4 times over before they finally decided who got it.
Wow.
And that's not even counting all the people who just waltz into their family's houses and take things.
Yeah, it is. It's one of the things that, I don't practice that. That's why I'm very interested in just learning from you. And I know as everyone else is listening, breaking it down into simple terms, and, because we've run out of time, it's one of those things where I know that it's kind of what I want to do today is just break down something very simple about the will process. And at least that's the first step to make sure that what it comes down to is what you want to happen. You can kind of create your own roadmap. It's like, going across the country, you can take the most direct route, or you can take a long route, but you know what the joy is? You get to pick the route. And so that's kind of what estate planning is. And I love it. So Ryan, thanks for joining today and really just giving us a very brief introduction, but really important advice on what people should do that are watching and listening today. So, one thing I failed to do is, I know you're in the Kansas City office, and I gave the St. Louis Metropolitan phone number. So obviously you can find us on the web at TuckerAllen.com. Ryan's up in Kansas City. We can schedule consultations there virtually via the phone, or in person where appropriate and where you feel safety is important to you, and have that conversation and see what's appropriate for you as well. So Ryan, thanks for joining today.
Absolutely. Thank you for having me.
So continue to tune in to our podcast, as we'll continue to bring you information like this to break down into more simple terms, something that maybe, you fear, you just don't understand. It's something you think you want to put off, but obviously education, learning, it's power, and it's something that will empower you to make the right decisions for you and your family. So visit us online at TuckerAllen.com. Give us a call at 314-335-1100. We'll be happy to talk you through that. Until next time, have a great week.